Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to hit the subscribe button. It helps our channel grow. For today's case, we're dealing with a supposed parody of a Dr. Seuss work, but really wasn't a parody at all. This deals with the "Oh, the Places You Will Go," written by Dr. Seuss, and "Oh, the Places You'll Boldly Go," written by Comic Mix LLC. This is a case of Dr. Seuss versus Comic Mix. In this case, Comic Mix produced a work that was very similar in style and drawing to Dr. Seuss's work and tried to claim it was a parody. Dr. Seuss disagrees and sues for copyright infringement, among other reasons. The court analyzes what is and is not fair use and what is and is not a parody. So, "Oh, the Places You Will Go," in this case, includes to court. Let's get started with this. In the Dr. Seuss classic book, "Oh, the Places You'll Go," also known as Go, the narrator counsels the protagonist on a path of exploration and discovery. The book closes with this note of caution. I'm sorry to say so, but sadly it's true that bang-up and hang-ups can happen to you. Enter "Oh, the Places You'll Boldly Go," also known as Boldly, authored by Star Trek episode authors David Gerrold, illustrated by Ty Templeton, and edited by fellow Trekkie Glenn Hammond, collectively Comic Mix. Boldly is a mashup that borrows liberally, graphically and otherwise, from Go and other works from Dr. Seuss, and uses Captain Kirk and his spaceship Enterprise to tell readers that life is an adventure, but it will be tough. The creators thought their Star Trek primer would be pretty well protected by parody, but acknowledged that people in black robes may disagree. Indeed, we do. Yeah, so some Star Trek creators, some Star Trek episode authors, produced a work that was very similar in style and imagery and message to Dr. Seuss's work, and said they thought it was pretty well protected by parody, but also said people in black robes may disagree. And yeah, the people in black robes disagree. Now, they thought it was protected by parody, and they also thought that the judges may disagree. So did they seek a lawyer to ask? Did they ask for a legal opinion from a lawyer? No, they didn't. They thought that maybe people in black robes would disagree, and they didn't think to themselves, maybe we should ask a lawyer what we can do or not do that would be within the bounds of fair use. They decided to just go ahead and make their work. You know, maybe you should have sought a legal opinion when you thought that maybe judges might disagree. Maybe that was a clue that you should have sought some advice. Didn't happen. Let's learn about the places that we boldly go, including to the Ninth Circuit. Yay. Go was the final book written by the late Theodore Geisel, better known by his pseudonym as Dr. Seuss. Many of the dozen books Dr. Seuss authored and illustrated were widely popular when they published and have remained so throughout the decades. Dr. Seuss was the top licensed book brand of 2017. I did not know that, but apparently they were the top licensed book brand of 2017. Who knew? Not Harry Potter, Dr. Seuss. Okay. Notably, Go has been the #1 book on the New York Times bestseller list every year during graduation season. It is a pretty typical graduation gift book. Boldly is not a licensed work of Seuss, nor is it a collaboration or otherwise an authorized work. Nevertheless, in May of 2016, David Gerrold, an author of a Star Trek episodes, and Glenn Hawson, vice president of a publishing company, Comic Mix LLC, decided to send the Enterprise crew to a new literary world. Gerrold and Hammond agreed to create a Star Trek primer, a mashup of Star Trek and another well-known primer. A mashup is something created by combining elements from two or more sources, such as a movie or video having characters or situations from other sources. So it's like, let's create a mashup of multiple works. Star Trek, which we have some familiarity with, and Dr. Seuss, which, we're just going to borrow from. That's not going to fly. The fundraising effort raised more than a few eyebrows when the Seuss organization became aware of Boldly. One fish, two fish, red fish, we're going to sue you, fish. In September and October of 2016, Seuss sent Comic Mix a cease and desist letter and 2 follow-up letters. Comic Mix responded that Boldly was fair use of Go. Seuss also sent Kickstarter a takedown notice under the Digital Millennium Copyright Act. Kickstarter took down the campaign and blocked the pledge funds. Boldly remains unpublished and will remain unpublished forever because, we could have got a lawyer to help us, but no, we didn't want to do that for some reason. The district court granted Comic Mix's summary judgment motion and denied Seuss's motion, holding boldly was fair use to go, and the remainder of the trademark claims failed. So the district court, the trial court, thought to themselves, this was a fair use. This is fair use. That's a legal determination, of course, and the Court of Appeals is going to sharply disagree, and I think somewhat legitimately for reasons we're going to see rapidly. As for the text of boldly, Hallman created side-by-side charts comparing the text of Go and Boldly in order to match the structure of Go. Boldly also closely mimics many illustrations in Go, as a result of what Comic Mix called slavishly copying from Seuss. In one instance, Templeton took to about 7 hours to copy a single illustration because he painstakingly attempted to make the illustration in Boldly nearly identical to its Seussian counterpart. That's a problem. Despite being slightly concerned, Comic Mix did not consult a lawyer or pursue the options of licensing. This failure led to a lawsuit. So, even though they were concerned about the legal implications, they at no point decided to seek a lawyer for help, a lawyer who could have alerted them to some of the problems that they were going to experience. It's like, no, this is fine. This is completely fair use, even though we're concerned it might not be. Maybe get a legal opinion would have been helpful. This lawyer's legal opinion would have been, yeah, maybe you want to reconsider some of this stuff for reasons we're going to see very quickly. Okay, so of course, as always, we must turn to the statutory fair use factors. So as we're going to look at the varying imagery that's involved in the varying things that were put here, it is a good idea to see what is and is not fair use under the law. So there is a 4-factor test. Now, these are non-exclusive factors, so these 4 factors and other stuff. But courts routinely go to these other 4 factors. It's a bit odd and a bit unusual for a court to find and other stuff. These 4 tend to be the dominant ones. So here is the 4-factor test for fair use. Here's how you determine what is or is not a fair use. First, the purpose and character of the use, including whether such use is commercial in nature or is for nonprofit educational purposes. So if what you're doing, so we're looking at this from the potential infringer's perspective. In this case, we're looking to what is the nature and character of your use. Are you selling it in a textbook? Are you selling it on the commercial market? Are you trying to make movies or other profitable works from it? Or are you using it in a classroom and teaching environment or a non-profit educational mission? Doesn't necessarily have to be in this formal educational environment, but which are these more are you in? Are you in the commercial use? Or are you in nonprofit use? Now, as we discussed earlier, this was part of a Kickstarter campaign for books to be on sale in the market. So that would be much more in the commercial sense than the nonprofit sense. We're trying to make money from it. So that would be more, the character of the use is more commercial in nature, right? So factor number 1 seems pretty clearly Dr. Seuss. Number 2, the nature of the copyrighted work. In this, we're trying to separate a factual work from a work of fantasy. So works that are more factual in nature, more collection of facts, have less or thinner copyright protection than works of fantasy. So a good example of a factual work would be something like a telephone book. It is a list of numbers. The facts themselves are not copyrighted. You can't copyright facts, but you can copyright arrangements of facts, including in a telephone book. And font stylization and other elements of the book can be copyrighted in its collective form, even if the elements are not. But even in that example, where the telephone book is copyrighted, it's a thinner copyright because it's a collection of facts. There's nothing creative about it, really. It's a collection of facts. So you have work of fact that are less copyright, and then you have works of fiction that are more creative in their endeavor, more artistic in their endeavor, that have a broader copyright protection. So is Dr. Seuss, is the original work more in the nature of fact or in the nature of fantasy? I mean, come on. It's a fantastical work. It's a work of fantasy. It's a work of creative enterprise. So this, again, dominantly goes to Dr. Seuss. The amount and substantiality of the work in relation to the work as a whole, we'd have to look at the actual drawings, so we'll get to that in a second, to determine how much of the work was copied or otherwise, so we'll get to factor 3 in a second. And factor 4, the effect of the market. Would this in some way displace the market? So would this work, if it's sold, would some people buy this book as opposed to buying the Dr. Seuss book? Would this harm the market for Dr. Seuss? And that would depend on part of, is it a substitute? Would some people buy, or a substantial number of people buy, the Dr. Seuss book or buy the other book? Which one will they buy? So if it produces an infringement of the marketplace, that's a factor. So we'll go to see how similar they are or not in trying to determine that. So factor number 1 and factor number 2, we can kind of determine on its face our favors in Dr. Seuss. Number 3 and number 4, we'll have to look a little bit more to the facts and how close they are. What is the amount and similarity? And what is the effect on the market? Would people buy the Star Trek book rather than the Dr. Seuss book? All right, let's figure that out as we look to the facts. As to the law elements, commercial use is no longer considered presumptively unfair. So just because it's commercial, just because it satisfies one of those 4 tests, because it's commercial in nature, it's no longer dispositive. In the past, this is considered more of a dispositive factor, but today not so much. So if just because it's commercial does not mean it's not fair use. It can be commercial and fair use, that's possible, but as explained below, this is indisputably a commercial use, and it does counsel against fair use. So it is a factor. It is no longer a dispositive factor, but it's a factor. So if you're doing it commercially, that's a factor against you. It's a factor, but still a factor. While the term transformative does not appear in the fair use analysis, this permeates the copyright analysis because the case law is such, the court has determined the central purpose of the factors is determining whether and to what extent a work is transformative. That's correct. So the word transformative doesn't appear. So this would fall into maybe the other stuff category. But the more transformative it is, the less likely it is to be an infringement, and more likely it is to be a new work. For something to be a transformative work, it must add something new with a further purpose or a different character. It must alter the first with a new expression, a new meaning, a new message. It has to actually, transform. On the other hand, a work that merely supersedes the objects of the original creation is not transformative. So to be transformative, it has to transform. It has to have a different message, a different meaning, a different expression. It has to be saying something different. It has to transform. If you merely supersede the original, that is not transformative. That's superseding, not transforming. Turning to the question of legal parody, what is and is not legal parody? The purpose and character of parody fares squarely into an example of fair use, criticism and comment, and has obvious claim to transform it. So parody falls within the definitions of comment and criticism and is transformative. By definition, a parody must use some elements of a prior author's composition to create a new work, that at least in part, and this is the critical aspect to parody, so pay attention to these last words because this is the critical part, comments on that author's work. A parody parodies the original. It makes a comment about the original. It's meant to hold the original, to ridicule. It is meant to make the original look bad or otherwise comment or critique on the work, right? So for something to be a parody, pay attention to these last words. It must comment on the work it's attempting to parody. It must be making a comment and critique of that work. That's what a parody is. Just because you borrow their stylization does not a parody make. You have to be critiquing the original in some way. Critical details here. If the commentary has no critical bearing on the substance or style of the original composition, which the alleged infringer uses merely to get attention or to avoid the drudgery in working up something fresh, the claim to fairness in borrowing from another's works diminishes if it does not vanish, and other factors like the extent of its commerciality loom large. So yeah, parody, to be a parody, it must have a bearing on the original substance or the original style. It must be critiquing it, commenting on it, bringing it up to ridicule. That would be a parody. Just because you borrow their style or stylization does not a parody work unless you're actually making the original. You're making a critique on the original. That's what a parody is. It has a definition. You must be making fun of, critiquing, commenting on the original in some way. Thus, boldly is not a parody. Comic Mix does not seriously contend that Boldly critiques or comments on the original. Rather, it claims that Boldly is a parody because it situated the violent, sexual, sophisticated adult entertainment of Star Trek in the context of Dr. Seuss to create a funny book. No. We considered and reject this very claim in appeal involving another well-known book of Dr. Seuss, because this is not the first time that someone has tried to do this with a Dr. Seuss book, The Cat in the Hat. In another case, someone tried to infringe on Cat in the Hat. The retelling of the O.J. Simpson double murder trial in the world of Cat, in a book entitled The Cat Not in the Hat, a parody by Dr. Seuss, was not, in fact, a parody of The Cat in the Hat. So someone tried to retell the story of the O.J. Simpson double murder trial using Cat in the Hat. That is not a parody because it is not trying to critique or comment on The Cat in the Hat. It is trying to critique and comment on the O.J. Simpson trial, not the underlying work. It is not a parody. You might have called it a parody, but it doesn't attempt to bring The Cat in the Hat into ridicule, comment, or critique. It attempts to describe the O.J. Simpson murder trial. That's not a parody. Now, we explained that broadly mimicking Dr. Seuss's characteristic style is not the same as holding his style up to ridicule. Right. There's a difference between using his style and critiquing, commenting, or holding his style up to ridicule. These are not the same thing. And without a critique of Cat, all Knott did was simply retell the Simpson tale using the expressive elements of Cat. That is not a parody. To get attention or maybe even to avoid the drudgery and working up something fresh. No, we have no problem you retelling the tale of the O.J. Simpson murder trial. That's perfectly fine. You can retell the tale. What you can't do is borrow someone else's stylism, creativity, their artistic elements without their permission. Come up with your own creativity. But you're like, oh, I want to borrow that. That makes it a parody. It does not make it a parody, no. Boldly's claims to parody fare no better. Although the elements of Go are featured prominently in Boldly, the juxtaposition of Go and Star Trek elements do not hold the Seussian style up to ridicule. We're not trying to comment on the Seussian style, or ridicule them, or critique them. We're just borrowing and lifting them. That is not a parody. That is not fair use. Nor is Boldly otherwise transformative. Comic Mix argues that even if Boldly is not a parody, Boldly is transformative because it replaced Seuss's characters and other elements with Star Trek material. No. Again, the Cat case repudiates this position. Their efforts to leverage Dr. Seuss's characters without having a new purpose or giving Dr. Seuss's works new meaning simply fell short of being transformative. The copyists merely used what Dr. Seuss had already created, the cat's stovepipe hat, the narrator, and the title, and overlaid a plot about the O.J. Simpson murder trial without altering Cat with a new expression, message, or meaning. It didn't bring any new meaning to the original. It didn't comment on the original or transform the original. It's just borrowed from the original. That's not how that works. Boldly's claim to transformative use rests on the fact that it has extensive new content. But the addition of new expression to an existing work is not a get-out-of-jail-free card that renders the use of the original transformative. The new expression must be accompanied by benchmarks of transformative use. Most telling is Comic Mix's repackaging of Go illustration. The Star Trek characters step into the shoes of Seussian characters in a Seussian world that is otherwise unchanged. Comic Mix captured the placement and poses of the characters, as well as every red hatch mark arcing over the characters holding hands in the Grinch iconic finale scene, thus plugged in Star Trek characters. So as we look at the two images, we see the original with a bunch of people holding hands in a semicircle on what looks like a globe with a bunch of red hash marks, and we see some text underneath below. And then in the quote-unquote parody work that's not a parody at all, we see essentially the same thing. A bunch of people that are in the same artistic style as Dr. Seuss. They look very similar to Dr. Seuss characters with the red hash marks in the same sort of orientation and style. And there's nothing about that that is critiquing the artistic style or holding it up to ridicule or comment. It's just straight up lifting one from the other. There's nothing paroditic about it at all on its face. Comic Mix copied the exact composition of the famous waiting place in Go, down to the placements of the couch and the finishing spots. To this, Comic Mix added Star Trek characters who line up, sit on the couch, and fish exactly like the waiting place visitors they replaced. Go continues to carry the same expression, meaning, or message. As Boldly's text makes clear, the image conveys the sense of being struck with time moving fast in the wink of an eye. Okay, so again, we can compare these two images side by side, and we can see quite a lot of similarities between the two images. They're very, very similar. We see both have a yellow background of rolling hills. We take a look at the hills. The hills look basically identical, if not extremely similar. They're basically identical. We see what looks like a clock hanging from a chain in the middle of the image. It's the same. We see on the Dr. Seuss original, one of the Dr. Seuss characters fishing from a tree into a fishing pole. We see very similar imagery in the copied work with people fishing into a very similar fishing hole. we see 4 Dr. Seuss characters sitting in the middle of the image, sitting on a couch, one with an umbrella. And in the copy work, we again see 4 very similar characters in a Dr. Seuss kind of style, in the same kind of orientation, one of which has an umbrella. And we see a very similar textual outlay. And we see also other similar elements, including people lining up, and one case for a gravestone and one moving up to a different kind of gravestone. We see the people lining up across the hill. And so we see a very, very similar style, very similar characteristics. They obviously are evocative, and it's obviously copying very directly. But there's nothing about the imagery that's attempting to mock Dr. Seuss. It's not attempting to comment on Dr. Seuss. Nothing about the text attempts to comment on Dr. Seuss. It's basically just lifting the exact same image without making any artistic creativity. There's nothing paroditic about it at all. There's nothing transformative about it at all. It's the exact same work. And so that's a copyright infringement. Comic Mix also copied a scene in Sneetches, down to the exact same shape of the sandy hills in the background and the placement of footprints that collide in the middle of the page. The Seussian characters were replaced with Spocks playing chess, making sure they had similar poses as the original, but all Comic Mix really added was a basketball crown of a weird basketball court. So again, in the 2 images, we can see what looks like, again, a yellow background with some more flat kind of hills in the background, just some slight bumps in an otherwise flat background. We see what looks like footprints in the sand. We see 2 people arguing on a slight hill or slight mound in the original in the background. And in the infringing work, we have the exact same hills in the background, this flat with some slight bumps. We see the exact same foot tracks leading up to the hill in the foreground that look exactly the same in terms of their dimensions. We see the 2 characters have extremely similar poses, and in the original, there's nothing in between them. In the new work, there's a chessboard, and in the background of the new work, appears to be some kind of basketball court or something like that. But again, there's nothing paroditic about this. What in the new work is commenting on the old work? What is holding it up to ridicule or comment or critique in any way? What about the text is doing that? What about it is making a comment on the original rather than just merely borrowing and lifting the original style? There's nothing creative about this. It's just merely borrowing. This is not a parody. This is infringement. It doesn't even come close. So any lawyer probably would say this seems like a really bad idea if you had asked the lawyer, because this seems like a really bad idea. Seems pretty infringing to me. Although Comics Mix works need not boldly go where no one has gone before, its repackaging, copying, and lack of critique on Seuss, coupled with its commercial use of Go, does not result in a transformative fair use. This first factor weighs definitely against the fair use. Yeah, no, not really. And then the second factor considers the nature of the copyrighted work, whether it's creative or not. Well, this is definitely creative work. This is not a factual work. This is not a collection of facts. This is artistic creativity. This is fanciful. This is a work of creative fiction. So the second factor, yeah, that's an easy analysis. That goes for Dr. Seuss without blinking an eye. The third fact asks whether the amount and substantiality of the portion of used in relation to the work is a fair use. So we look at how much was used in terms of the overall work. The quantitative amount taken in boldly is substantial. To be sure, we understand that the inquiry under this factor is flexible, rather than a simple determination of percentage. It is flexible because you can use 100% of the work and it not be an infringement. And for that matter, you can theoretically use 1% of the work and it would be an infringement. So again, it is a factor to be determined. You can use 100% of the work if it is transformative, if it's critiquing. You can get away with using quite a lot. In fact, all the work if it's sufficiently transformative. And there's a point where you can use only 1% and it not be transformative at all. So it is flexible and it's not just based on percentages alone. But that being said, Comic Mix copying was considerable. It copied 14 of the 24 pages of Go, close to 60% of the book, and significant illustrations from Grinch and 2 stories in Sneetches. Critically, Comic Mix does not merely take a set of unprotectable visual units, such as a shape here or a color patch there. So yeah, some of the elements are not copyrightable. So if you use the color scheme or some of the shapes, that's one thing, but that's not exactly what happened here. For each of the highly imaginative illustrations copied by Comic Mix, it replicated as much and closely as possible from Go. They are pretty close. The exact composition, the particular arrangement of visual components, and swatches of well-known illustrations. This is not a parody. This is not a fair use. This is just straight up infringement. Yeah. Again, we turn to Boldly itself for illustrative examples. Here, Comic Mix replicated the overall composition and placement of shapes, colors, and detailed line work. So if we look at the original, we see a Dr. Seuss character running up the middle of a path of what could be determined maybe like a garden, I suppose, of a yellow surface area with what you might describe as hedges on either side of the common path. And these hedges alternate in pink, blue color scheme. So you got pink and then blue, and then a wider portion with a narrower pink strip, and then a wider blue, wider pink. So you got these kind of narrow, these two wider ones, then a narrow pink one in the middle, followed by two wider ones. And then if we turn to the infringing work, we see, it's just the exact same arrangement in the exact same color scheme with the exact same level of thickness. We got pink, blue, pink, blue. Again, the middle pink is thin, just like the original. And we got the same kind of character running up the middle and in basically the same position, even down to the footprints in what I guess we'll call sand of the background. And all we've added is some additional characters to the otherwise background. I mean, we've even got the hills in the background, in the far background on the left-hand side. We've got two hills in the background of the original, and on the original, and the hills basically look exactly the same. What about this is making a parodic comparison? What about this is upholding the original to ridicule or critique or comment? Nothing. It's just straight up lifting it. It's the exact same color scheme. This is not parody. This is not transformative. It's not even close. Incidentally, for those of you who are wondering, yes, this would qualify as fair use because at this point, I'm making critique and commentary about the works in relative comparison. So yeah, I'm making a critique and commentary. I'm definitely commenting on the original to a great extent, and I'm critiquing and commenting on both the original. So this would be what fair use looks like. This is what transformative is. Yes, I'm using it. I'm using a lot of the work, but I'm critiquing and commenting on it, making comparisons and analysis. This would be what fair use looks like. What they did is not fair use. So see, I'm using basically the same amount of the work. I'm using the same amount of the work as they did. This is fair use, and that was not fair use. So the amount of the work is not dispositive, nor is the fact that this is kind of commercial in nature because I'm making money off of it. Although it's also educational, so there's that. So it's kind of a mixed one on that one. So it's both kind of commercial and kind of educational. So it's kind of somewhere in the middle on that factor about whether this is more commercial in nature or not. It's kind of in the middle. I'm using as much of the work as they did, but this is fair use. Theirs is not. Comic Mix also took the overall composition of Seuss's illustration, the placement of the tree, the hills, and the white space surrounding these elements. The trees in both versions have the exact same number, bends, and lengths of branches, with the same branch in both versions hoisting a dangling finger. Comic Mix's verbatim copying the original weighs against fair use. So if we turn to the two comparative images, in the original Dr. Seuss work, we have what looks like a hill maybe, or a sharp hill jutting out of the left-hand corner of the screen, with a tree that has three branches in a particular configuration. And if we look, and there's also what looks like some sort of pink moss or something growing at the bottom of the base of the tree on the hill. And if we look at the infringing work, again, we see the exact same tree, nook for nook, curve for curve, with the same pink moss at the bottom. And also off the exact same branches in the original that has someone dangling from it. In the copy, we have someone dangling from it. And we have the exact same hills as we see in the two backgrounds. We've got a hilly surface followed by two hills in the background, and the same in the original. The same hilly surface with the two hills in the background. Slightly different color schemes, but the same. And all we've done is we've added a few additional characters. How is this commenting or critiquing on the original? It's not. It's just merely ripping off their artistic style because they're too lazy to come up with one of their own. This is not a parody. This is not transformative. It's not close. Comic Mix took the heart of Dr. Seuss's work. For example, Comic Mix copying of Sneetch's illustration exhibits both extensive quantity and quality of taking by Comic Mix. Sneetch's is a short Dr. Seuss story about two groups of Sneetches, the snooty-starred Belle Sneetches and starless ones. The story's plot, character, and moral center on the highly imaginative and intricately drawn machine that can take the starry-shaped status symbol on and off the bellies of Sneetches. Different iterations of the machine, the heart of the Sneetches appears in 10 out of 22 pages of the book. Comic Mix took the highly expressive core of Sneetches. Templeton testified that the machine in the Starbelly stories was repurposed to remind you of the transporter in Star Trek. Drawing the machine took about 7 hours because Templeton tried to match the drawing down to the line work of Seuss, and I think pretty much succeeded. He painstakingly attempted to make the machines identical. In addition to the machine, boldly took the poses that the Sneetches are in, so the poses of Commander Scott and the Enterprise crew getting in the machine are similar. Boldly also captured a particular crosshatch and how Dr. Seuss rendered the machine, the puff smoke coming out of the machine, and the entire layout. So if we go to the two images, again, we see this transformation machine on the left and the right, which are exactly identical. So on the left, we've got this yellow machine with its cogs and wheels, people entering the entrance of the machine, and then the people being spit out at the end with some lines indicating, I suppose, velocity, and it's the exact same image on the right. It's the exact same machine with the exact same orientation. We got the exact same puffs of smoke coming out of the machine. We got the exact same exit lines coming out of the machine. We got people lining up to enter the machine on the left, or the original. We've got they're lining up to enter the machine on the right in the copy, and we got them being spotted out of the machine in the exact same characterization and style. The machines are identical right down to, I guess we'll call it the shadow of the machine, the black line drawings. So yeah, and it's on the exact same hill with the exact same curve, and we slightly changed the color backgrounds, but yeah, those are the exact same machine with the exact same poses. They even got down to the way the characters are sort of hunched over between the two. So if you look at the original, the way that the characters are sort of hunched over in the original, we got that even down in the copy where it's down, and we've replaced the guy who is offering to enter this machine. We replaced him with Scotty, and basically it's exactly the same. So yeah, how is this commenting or critiquing on the original? It's not. This is not transformative. This is just infringement. Works like Boldly would curtail Go's potential market for derivative works. This is not the case where copyist work fills the market the copyright owner would likely avoid, as is true for a lethal parody or a scathing theater review. In fact, Comic Mix hoped to be one of the potential markets for Seuss's derivative works before Seuss, believing Seuss would want to publish it themselves and give Comic Mix a nice payday. That's super good. So they made this work in the thought that, you know, Dr. Seuss would want to buy their work and give them a nice payday. Well, what's going to happen now is Dr. Seuss is going to get the copyright for free as part of their damages. Probably, I'd imagine they're going to get the copyright free, and then they're just going to be able to publish it with no royalties to anybody, because that's going to be part of their overall damages, I would guess. So if Dr. Seuss wants to publish "Oh, the Places You'll Boldly Go," they probably can without paying anybody because their copyright was infringed on. Good work there. Hope you enjoy your 0 royalties that are coming your way. Way to go. Maybe royalties to Star Trek. The court will think about it, I'm telling you. I mean, I don't think it's a frivolous thing that there might be some royalties to Star Trek. It's possible. But I mean, if they had, you know, I don't know, man. Because it depends what rights they had to the Star Trek characters in the first place. If they had rights to the Star Trek characters in the first place to make the work, I'm not sure that they have to pay any royalties. I mean, it'll be interesting when it actually comes out, you know, which way that goes. But thus, that brings us to the end of the case of Dr. Seuss Enterprises versus Comic Mix. In this case, Comic Mix produced a very infringing work of Dr. Seuss's materials with no artistic creativity at all and no parodic use or transformative use. They just completely lifted it without paying any licensing fees. Apparently in the hope that they would get a licensing deal from Dr. Seuss. And this is going to be, there's going to be damages, and the damage may include the copyright. So the licensing deal might include, how about we just take your work for free and we just publish it forever and we don't pay you anything? How about that for a licensing deal? But this is definitely not a parody. It's not even close. To be a parody, you have to critique the original work. How are you critiquing the original work? What are you saying about the original work? How are you transforming the original work's meaning? You're not. It's just ripping off the artistic elements. That is not a parody. It is not transformative. This is copyright infringement. So I'm not 100% sure what the district court was thinking, but this seems pretty easy in the end. So that brings us to the end of the case of Dr. Seuss versus Comic Mix. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.